So this is on California courts and the Legislative Open Records Act. The main appellate court case involving the Legislative Open Records Act, or LORA, L-O-R-A, is the case of Zumbrin Law Firm versus California Legislature decided in 2008. In that case, according to the court, the legislature's response to a LORA record request satisfied the statutory requirements that the legislature, among other things, justify in writing the withholding of exempt records, where the legislature's response stated that any additional responsive documents in its possession fell within the statutory exemptions, and that they stated that examples of such exemptions were preliminary draft notes or legislative memoranda, as well as correspondence of and to members of the legislature and their staff, and finally, records, the disclosure of which is exempted or prohibited. Unlike an evidentiary privilege under the California Evidence Code, an exemption from LORA is not waived when some documents are disclosed. Now, in this case, the court explained that the plaintiff, the Zumbrin Law Firm, brought this action as a taxpayer against the defendants, the California legislature, and its rules committees, among others. And they sought declaratory and injunctive relief, claiming that a contract for the Capitol Park Safety and Security Improvement Project entered into by the Committees on Rules of the Assembly and Senate in order to improve security measures at the Capitol violated the separation of powers doctrine of the Constitution and also unlawfully restricted competitive bidding under the State Contract Act. Now, the plaintiff also sought some records relating to the contract under LORA. The trial court concluded that the contract did not violate the separation of powers doctrine nor the State Contract Act. The court also concluded that the denial of discovery of certain records did not violate LORA. And the Court of Appeal agreed with the trial court in all three of these instances. They said that they went to explain that the development of the LORA statute was enacted in 1975, Chapter 1246 of the Statutes of 1975. And LORA generally provides for the open access of information concerning the conduct of the people's business by the legislature. This is set forth in Government Code Section 9070. LORA also specifies several categories of records that are exempt from disclosure, including correspondence of and to individual members of the legislature and their staff, among other things. Now, also relevant here is the language of Section 9075, both subdivisions H and I, and those were originally enacted in 1979. In addition, the appeals court described the interaction between LORA and Prop 59. So in 2004, the voters of this state approved Prop 59. This added Subdivision B to Section 3 of Article 1 of the state constitution, and it provides generally for open access to information concerning the conduct of the people's business. Now, unlike the LORA statute, this provision of the Constitution also provides for access to the meetings of public bodies, as well as the writings of public officials and agencies. Now, the Court of Appeal in the Zumbrin case explained that Prop 59 expressly does not change or repeal any exemption to disclosure provided by Article 4, Section 7, or by state law or legislative rules that were adopted. The exemptions specified in LORA are state law exemptions. The mere coupling of these exemptions, the court said, with those in a particular constitutional provision does not create an ambiguity. Also, the court said that Prop 59 pertains to the right of access to both government documents and meetings of public bodies. The exception contained in Article 4, Section 7 refers specifically to the proceedings of the legislature and allows closed sessions for certain specified purposes. On the other hand, LORA applies not to the proceedings of the legislature, but to the disclosure of its records. The specifically enumerated exceptions in Prop 59 are qualitatively different. One applies to proceedings, one applies to documents, and one applies to both the legislative rules. Because they are different, it cannot be said that the electorate intended one example to restrict the other examples. For this reason, the Court of Appeal rejected the plaintiff's claim that the provisions of Prop 59 conflicted with the terms of the Laura statute. The appellate court also ruled that the legislature had complied with Laura. It said that the plaintiff argues defendant's response to the records request did not comply with Laura's requirements, that if any records were exempt from inspection, that the defendant justify in writing the withholding of such record by demonstrating that the record in question is exempt under express provisions of the article found in section 9074 of the Government Code. The plaintiff also points to documents that were disclosed during the course of the litigation, but they were not disclosed in response to the initial Laura request, and the plaintiff claimed that these documents proved that the defendants did not properly comply with Laura. However, the later produced documents, according to the appeals court, were not responsive to the plaintiff's initial request. The Court of Appeal also ruled that the legislature did not waive the right to withhold documents. Just because the Department of General Services disclosed some of those documents, they determined that it did not violate Laura, but there was also not a waiver by the legislature of the exemption. With regard to the argument that was espoused by the plaintiff, the appeals court concluded that the statutory exemptions from disclosure are not the equivalent of evidentiary privileges which may be waived by disclosure. Privilege, as defined by the Evidence Code, they said, relates to proceedings in which testimony may be compelled by law to be given. The plaintiff cites no authority to support its claim that an exemption to Laura's open records policy is to be treated as if it were an evidentiary privilege subject to waiver if it's disclosed. So again, this case dealt with several different exemptions under Laura, as well as the interaction between Laura, the state's Public Records Act, and Prop 59, which includes public access to meetings and the writings of public officials.